Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning to the attorneys in this case.
Morning, Your Honor.
This is your panel for the Court of Appeals. We welcome you, Judge Frison and Judge Davis and myself, Judge McClarity. As we proceed in this matter, if there's any technical difficulties that develop, please let us know immediately so they can be addressed and corrected. Also, we will proceed in this case as if you were in court, except you will not need to stand to make your presentation, okay? I assume that the parties, that the appellant has reserved his time for rebuttal at this point. Is that correct?
Yes, Your Honor. 2 minutes.
And if there is nothing further, Madam Clerk, are there any motions that need to be considered before we begin?
No, Your Honor.
Then will you call the first case?
Deric J. Mead versus James Loyd Tucker.
For the
Morning, Your
appellant.
Honor. I'm sorry.
Go right ahead.
Thank you. My name's Thomas Bailey. I'm an attorney from Nashville, Tennessee, and I represent the appellant in this matter. This is our appeal from the trial court's dismissal of the case following finding the plaintiff failed to file a proper motion and an amended complaint pursuant to Tennessee Rules of Civil Procedure 25.01 in order to substitute the personal representative of the defendant that deceased during the discovery phase of the claim and found that there was no excusable neglect in doing so, Your Honor. So the issue before the court is whether the trial court erred in denying the plaintiff's motion for extension of time to correct the timely but deficiently filed pleading that did purport to substitute the party pursuant to Tennessee Rules of Civil Procedure 25.01 and finding that the plaintiff failed to establish excusable neglect within the meaning of Tennessee Rules of Civil Procedure 6.02 during hectic, chaotic, unusual circumstances, including working remotely because of COVID-19. So the standard we're asking the appellate court to apply in this case is abuse of discretion standard and finding that the trial court's ruling was against logic and reasoning according to the record and thereby cause an injustice to the plaintiff. Your Honor, that's pursuant to State v. Shirley. So the relevant facts are this. The plaintiff filed a complaint timely under the rules of procedure. Plaintiff filed a summons timely under the rules of procedure. Plaintiff renewed the summons after inability to serve defendant timely under the rules of procedures. Plaintiff served the defendant timely under the rules of procedure ultimately. The case did languish for some degree during written discovery because the plaintiff had moved out of state and for a period of time had become unavailable. There was no trial date set. After plaintiff fully answered written discovery, the defendant deceased. So shortly thereafter, a suggestion of death was filed and of course implicated Tennessee Rules of Civil Procedure 25.01, requiring the plaintiff to file a motion to substitute the personal representatives of the deceased in favor or in place of the deceased by filing a motion to do so along with the amended complaint. Plaintiff on the 90th day, and that was August 20, did indeed file a pleading. And the pleading was an amended complaint inartfully naming the personal representative of the state as the defendants and inadvertently failed to attach the motion for substitution. So on 9/4, defendant filed a motion to dismiss the case for plaintiff's failure to timely file the motion pursuant to Rule 25.01. So 12 business days later, that's on 9/22, plaintiff filed a motion to enlarge time to file corrective pleadings. 15 days later, which would be 36 days beyond the requisite 90 days, and that would be not September 25, plaintiff did indeed file the motion for substitution of the parties, a corrected amended complaint, and an affidavit or sworn declaration explaining the cause for the delayed filing, to include primarily issues related to COVID-19 recommendations to work remotely and maintain social distancing. So with less in-person interactions resulting in a partially incomplete calendaring issue, typically the procedures for my office is to have a deadline and then have a tickle, if you will, 10 days before that deadline. That did not get done for whatever reason. So, Your Honor, and then I failed to properly download a motion that was uploaded on my assistant's computer by mistake, inadvertent, Your Honor. And so the difficulty downloading the correct digital file containing the motion for legal assistance computer, despite, again, procedures in place to prevent these problems. In fact, these problems have not happened in the past. So that was the substance of the sworn declaration that we submitted to the court. So appellant's primary position here is twofold. Number one, that the United States Supreme Court's framework for analyzing excusable neglect in Pioneer and accepted by this court in Sizemore, adopted by the Supreme Court in Williams v. Baptist Memorial, was inappropriately applied by the trial court in its order finding no excusable neglect existed. And two, that the trial court erroneously adopted defendants, I contend, unsubstantiated findings of facts and conclusions of law submitted by the defendant in its memorandum of law in support of his motion to dismiss and in its proposed order of dismissal, without the court exercising its own deliberations and decisions as required in the Tennessee Supreme Court case of Smith v. UHS of Lakeside. I have that citation if the court requires. I'll go ahead and cite it. That's located at 439 Southwest 3rd, 303 at 314. And that is a Supreme Court 2014 case. So regarding the first position, our primary position is that pursuant to the holding in Sizemore, excusable neglect can indeed encompass omissions to act caused by carelessness, a situation where a party's failure to comply with the filing deadline is due to a party's negligence, that even if the reason for neglect is unpersuasively excusable, I should say, neglect can still be found if the other factors favor a finding of excusable neglect. The same is cited, again, we said that's in Sizemore, but the same is cited in Dubus v. Loyd, and that's cited as 540 Southwest 3rd, 4 at 13. That's a Court of Appeals case 2016. But additionally, under the Dubus excusable neglect justified an enlargement where there was no prejudice, to the non-moving party. So this court again in Kenyon v. Handel, Handal, site 122 Southwest 3rd at 755. That's a Court of Appeals case 2003, held that enlargement should be granted where failure to meet deadlines does not delay the case and when denial would leave plaintiff without support for the case. So these are just some reasons that, we find that, the court's conclusion was illogical against the record and resulted in an injustice to the plaintiff in this case. So excusable neglect is indeed an equitable determination based on circumstances surrounding the party's omission, the courts have found. Therefore, this framework is an analysis primarily, focusing on the reason and the issues relevant to the cause for the delayed filing. And so The trial court applied the framework and did consider the four analyses laid down in Sizemore, and that is one, the danger of prejudice; two, the length of delay and the potential impact on the proceedings; three, reasons for the delay and the filer's bad faith. The court did apply those factors, and our position is that it illogically concluded contrary to the record, and in finding there was no excusable neglect, and thereby again causing injustice to the plaintiff by dismissing the case. And so, particularly referring to the order, the court found with respect to risk and prejudice of the delay. Let me just say this: the record makes clear there's no danger of prejudice to the defendant because mere delay does not constitute prejudice under Pioneer Sizemore. And the record makes clear that the complaint was filed and answered. No surprise by the late filing of the motion of substitution. There was no scheduling order. No trial date was set. No disruption of legal proceedings. No detrimental change in the defendant's position and reliance on plaintiff's late filing. There's no denial of the defendant's ability to present an effective defense because of the late filing. The defendant was served and aware of the on a timely basis, the deficiency of the filing. He received notice of it. The personal representative received notice of it. So it's not a surprise. With respect to length of delay, corrective pleadings were filed a little over 30 days beyond the 90 days requirement by the Rule 25. So little no impact could possibly result. However, the court found in its order that delay was substantial and unreasonable based on supposedly plaintiff's stated awareness of the deficiency of the 90th day and knowingly and flagrantly choosing to ignore Rule 25. That is absolutely contrary to the sworn declaration submitted by the plaintiff and in contrary to the transcript for the oral argument of the hearing. Both stated plaintiffs were unaware of the deficiency on August 20. As to reason for delay, it was both within and outside the plaintiff's control to be sure of the calendaring of the issues, the failure of the office to download the proper file from a remote computer, from an assistant working remotely from each because of the COVID-19 pandemic. So I think those things speak for themselves. There are things inherently detrimental or disruptive to normal business of the attorney as a result of working remotely. Here, the court ignores plaintiff's sworn affidavit that the fact of COVID social distancing recommendations clearly disrupted normal business. As to bad faith, cannot exist in light of the fact that there was no strategic advantage to be had. And the filing, although imperfect, was filed and served timely. However, the court found that the bad faith because extensive non-compliance with the court's deadline. The record makes clear that the missed court deadlines only pertain primarily to discovery responses, which have been satisfied by August 20 date of the failure to properly file, and ask the court its discretion to hear the pending motion or to dismiss, a motion to dismiss or to set the case for a next available date. So those, again, there's no evidence in the record that there's any bad faith there. Essentially, our argument is that the factors of Pioneer framework weigh in favor of finding excusable neglect and the plaintiff's motion to large time to file the corrective pleading should have been granted, but the other factors so heavily weigh in favor of excusable neglect, such as to warrant the court's finding excusable neglect, even if it doesn't buy plaintiff's argument for the reasonableness of the delay, as was presented by the submitted sworn declaration. There's no evidence presented by the defendant that controverted plaintiff's or counsel's sworn declaration explaining the cause for delay. Regarding point 2, the court order mandate misstated the facts upon which the court bases ruling, and those facts appear to comport with the defendant's arguments and proposed final order, which we argue gives pause to whether the court exercised independent judgment of the facts. And
you may conclude your argument, wind it up at this point. Your time has expired.
Okay, thank you. which gives pause to whether the court exercise its independent judgment of facts and conclusions of law as required by Tennessee Supreme Court in Smith v. UHS of Lakeside, Inc., Your Honor.
Thank you. Thank you. You have your time for rebuttal. And for the appellee, yes, sir.
Morning, Your Honor. My name is Deric Lyons. I'm an attorney in Brentwood, representing the late Mr. Tucker. The only question before the Court of Appeals today is whether the trial court abused its discretion when it declined to grant Mead's late filed September 22nd, 2020 motion to enlarge time. As Mr. Mead's counsel has stated, Mead missed his deadline to substitute the parties under Rule 25.01. And because the motion to enlarge time was filed 33 days late, Rule 6.02 provided that the trial court could only grant an extension of the Rule 25.01 deadline if the trial court found excusable neglect. The trial court declined to find excusable neglect for several reasons. First, Mead's counsel offered contradictory excuses, which the trial court found were not credible. Second, Mead had repeatedly missed other deadlines in the case, not least of which were previous discovery deadlines. He'd had a motion to compel order entered against him because he did not oppose the motion or show up at a hearing. He had a second motion to compel pending just a few months prior. And he had, moreover, and this was listed as an independent grounds by the trial court, he had waited so late to file his motion to enlarge time that it could not timely be heard under the rules of civil procedure before the hearing on Tucker's motion to dismiss. And ultimately, the trial court did not abuse its discretion. Discretionary rules necessarily give the trial court choices among acceptable alternatives, and denying Mead's motion for an enlargement of time was well within the range of acceptable alternatives offered by Rule 6.02. I think it's very important to remember that the standard here is excusable neglect, not mere cause shown. By focusing only on bad faith and prejudice instead of the reason for delay and the length of the delay, plaintiff is asking the court to reduce the heightened excusable neglect standard down to a standard of good cause. The abuse of discretion standard, which the court is applying here today, is deferential. It imposes a heavy burden on appellants like Mead. The Court of Appeals customarily defers to the trial court regarding enlargements of time. Appellant review of discretionary decisions is less rigorous, with a decreased likelihood of reversal. Trial courts have substantial discretion to control the disposition of cases on their dockets. And this is a prime example of the court controlling the disposition of cases on its dockets. Mead had repeatedly missed his deadlines up to this point. And the court found that the additional deadline that he missed had not been missed due to excusable neglect. When a trial court makes a discretionary judgment and the case is appealed, the Court of Appeals does not second guess the court below or substitute their discretion for the trial courts. They apply the abuse of discretion standard, which constrains their review. Importantly, evidence that's used by a trial court for a discretionary decision is presumed correct and reviewed in the light most favorable to the decision. Mead claims in his argument that the trial court adopted the facts that we alleged. But what the trial court did and what the trial court's order makes clear is the trial court saw the facts that were in the declaration submitted by Mead's counsel and the facts that were presented by Mead at the hearing. And it concluded that the real reason for his delay, taking his statements as true, was that he glanced at a document and he assumed that it was the correct document. He didn't actually review it or read it before he signed his name to it twice and served it. And that was the story, the ultimate story that Mead's counsel presented. And the court found that that was not credible because the Mead's counsel had never explained to the court what happened to that document. He couldn't account for where the document was. He stated that he hadn't reviewed the document despite filing a sworn declaration explaining that he knew that this was a motion for substitution. Later, he said he didn't actually know what the motion was that was in the email that he got from his legal assistant. These statements taken together reduced Mead's counsel's credibility in the eyes of the court. And so ultimately, Mead has not satisfied his heavy burden of showing abuse of discretion. So the abuse of discretion standard has three potential factors. First, the application of an incorrect standard. Second, reaching an illogical or unreasonable decision. And then third, basing a decision on a clearly erroneous assessment of the evidence. Mead does not argue that the trial court ever applied an incorrect legal standard. There's no dispute that August 20, 2020 was the Rule 25.01 deadline. There's no dispute that Mead did not serve a motion for substitution or notice of hearing on the personal representatives. Mead states that he that he had served the personal representatives. What the record shows is that at some point, Mead had served his first amended complaint on them. The Mark Tucker, one of the personal representatives, received service on or around September 4th, the same day that we filed our motion to dismiss. And Pam McDuffie's service was undated. At any rate, what they were served with was apparently the first amended complaint. They were never served with a motion for substitution or notice of hearing under Rule 4. And that's what Rule 25.01 provides, must be done. Second, there is no argument from Mead that the excusable neglect standard did not apply or that the pioneer factors did not apply. So ultimately, there's no argument that an incorrect legal standard applied. Mead has now claimed that there was a clearly erroneous assessment of the evidence because the trial court adopted the findings of fact in defendant's motions. That is not an argument that he has raised up to this point. In his briefing, he raised the conclusory argument that the trial court's ruling was against the weight of evidence, but he never argued exactly why it was against the weight of evidence. So that is not a factor that should be before the court today. What Mead hung his hat on in his briefing was the logical and reasonable conclusion factor, which is the final prong that the court can use to determine an abuse of discretion. But going through each of the four pioneer factors, it's clear that the trial court's decision was, again, well within the range of acceptable alternatives. And again, the question today is not, did the trial court make the exact decision that the Court of Appeals would make if the Court of Appeals was sitting in the judge's shoes? The question is, did the judge choose an option that was within the range of acceptable alternatives under the rules? The reason for delay is the first pioneer factor, and it was stated in Pioneer, and it's been stated by this court that is perhaps the single most important factor, because not all negligent acts are excusable. Mere oversight or neglect, carelessness, and stress in and of themselves are not excusable neglect. They're not a good reason for excusable neglect. A misunderstanding of the law, a breakdown of internal procedures, and the like, again, are not good reasons for excusable neglect. And although the plaintiff's counsel details how COVID-19 and breakdowns and internal policies and procedures at his office were the reason for his neglect here, if you look at his declaration and you look at what he told the trial court, that's ultimately not the case. COVID-19 may have caused him to be working from home, but that working from home is not what caused him to file the wrong motion, according to what he's presented to the court. The failure of his legal assistant to calendar the deadline is not what caused him to miss the motion, because he was clearly aware of the deadline and he filed something on the deadline. What caused him to file the wrong document, according to what he represented to the court, was that he received an email from his legal assistant. He glanced at it. He chose to download the first amended complaint only, did not download the motion, apparently did not review the motion, and then signed and filed the first amended complaint without ever going back to check. Again, he said he glanced at it and he assumed it was all there. That's not the standard that lawyers are held to. That's not the standard that Rule 11 holds us to. That's not the standard that the rules of professional conduct hold us to. We have to review pleadings. We have to review filings and motions. We're not permitted to just assume that what our legal assistant sent us is correct. And here, again, apparently his legal assistant sent him the correct thing. He just did not open it. And when the trial court asked him, well, have you reviewed that since September 4th, since Tucker filed his motion to dismiss? And he said no, even though he had provided, again, a sworn declaration as to its contents. And Tucker's counsel stated in argument at the hearing on the motion to dismiss, we asked him, could you provide us a copy of the motion to dismiss that you say you had ready, so that we can review the metadata, so that we can see that you actually, what you're telling us is correct? And he ignored that request. And the court asked him, well, do you know what happened to that motion? And he said no, he didn't know what happened to that motion. He didn't know if his legal assistant still had it, even though, again, this was a motion that had been emailed to him. These contradictory reasons ultimately led the court to say that his reasons were not credible. The second factor, the second pioneer factor, bad faith, also weighs against Mr. Mead because there was a pattern of delay here. And again, that pattern of delay extended not only to the failure to respond to the uninsured motorist carrier's written discovery for 6 months and not attend the motion to compel hearing. It didn't just extend to the failure to respond to Tucker's written discovery for 5 months. It extended to the fact that he did not file a motion for substitution until 33 days after he missed the deadline, right before the hearing on Tucker's motion to dismiss. Yeah, this is not a case where if he had filed the motion to enlarge time on the day of the deadline, we would not be here today. He would be under the for good cause shown standard. He would not be under the excusable neglect standard. If he had filed it the next day, the day after the deadline, if he had reviewed his pleading, then we may also not be here today. At that point, it would have been within the discretion of the judge to make that call. But instead, and again, he didn't file it on September 5th after Tucker filed his motion to dismiss. He waited until 4 days before the hearing, 4 business days before the hearing, too short to have it heard under the rules of civil procedure, too short for it to be heard under the local rules. And at that point, he asked the court for more time. And if you miss a deadline to ask for more time, the trial court is well within its discretion to deny you more time. Finally, the danger of prejudice to Tucker is, again, an argument that is very important to Mead. We would remind the court that the word excusable would be read out of the rule if inexcusable neglect could be transmuted into excusable neglect by the mere absence of harm. And here, there was prejudice to Tucker's personal representatives. The cases that Mead has cited to show no prejudice do not apply. For instance, courts have found no prejudice when there was an admission of liability. There's no admission of liability here. Courts have found no prejudice when the substitution was of the plaintiff and the other party had already been in the case the whole time. Again, the facts are exactly opposite here. The personal representatives were foreign to the complaint. They'd never been added to the action. They were not parties at all. And then finally, in the Douglas case that Mead relies on, the court found no prejudice because they had notice. And here there was no notice because the First Amendment complaint was filed with no motion to substitute. And it's important under Rule 25.01 to have the hearing and the motion to substitute to determine that the personal representatives are the personal representatives who should be added. What's very important to remember also is that the onus is on Mead, not on Tucker, to show that there was no prejudice to Tucker. The onus is on Mead throughout this, not just as the not just as the appellant, but also as the movant for an enlargement of time. They have the duty to show that these 4 pioneer factors weigh in their favor. And on appeal, the appellant has the duty to prepare the record to show the court that that abuse of discretion occurred. So if the court reviews the record and finds insufficient data to make its decision, that weighs in favor of affirming the trial court. And again, the reason for delay and the length of delay factors are what separate excusable neglect from for cause shown. If Mead had not missed his deadline, under 6.02, he would have been subject to the for cause shown standard. And although the Tennessee courts have not fleshed out what for cause shown, federal courts have, and in Wagner versus Frazier, Tennessee Court of Appeals said that the rules, the federal and the state rules, were fairly close to being identical. Good cause under the federal rules is the absence of prejudice and bad faith. What separates good cause, for cause shown from excusable neglect is looking at the reason for the neglect, looking at the length of the delay. So again, it is excusable neglect. It's not mere neglect. It's not unprejudicial neglect. It's excusable neglect. And here Mead has not shown a good excuse. Finally, the trial court acted independently. The court speaks through its orders. Williams versus City of Burns has made clear that it's well settled that a trial court speaks through orders and the appellate court reviews the written orders. The court told the parties it would either sign or modify the orders that were submitted. It did not say, I will just sign whatever you send me. And the Court of Appeals has held that in the absence of evidence to the contrary, this court will assume that the order approved by the trial court accurately represents the court's reasoning. The test is whether or not there was independent legal reasoning and judgment. The court showed independent legal reasoning and judgment in its questions and oral argument at the hearing. And the court showed that it was going to sign or it was going to modify the orders that it received. And moreover, Mead waived this argument because he didn't raise it in the trial court. He's not allowed to raise self-serving arguments now that he did not raise before. He didn't object to the court's request that the parties send competing orders. The only reason that he raises this now is because the court did not choose his order. So I thank you, Your Honors, and I ask that you find that the court did not abuse its discretion in this case.
Thank you, sir. For the appellant, your rebuttal.
Thank you, Your Honors. Just for a point of clarification, the counsel for defendant says that the plaintiff had contradictory excuses. And the court order did find something to that effect. Our position is there's nothing within the declaration of what the cause of the delay was that was contradicted. It was expounded upon. Did not say that the assistant emailed the declaration said that it was downloaded from the assistant's computer and accidentally downloaded an incomplete file. Typically, it's in one file, but it was in two files. I did not realize that when I downloaded it. I stated in oral arguments that I believe that the motion with the file was the correct motion. I said that I could not speak to it because I had not actually seen it. So I didn't want to speak out of turn. I said that I didn't look at it because I prepared a new one. The court did mention that some concern about the fact that I waited to file the motion to substitute the parties, and I didn't do it on the 20th day. But again, on the 20th day, my declaration and testimony was I didn't know it on the 20th day. I didn't know that there was a deficient filing until after the defendant filed the motion to dismiss. So the court based its conclusions on several erroneous facts. The facts include the plaintiff filed an untimely response to opposition. That's false. But on the morning of the hearing, the plaintiff submitted for the first time a declaration for explaining the failure to file timely. That's false. It was filed several days before. That the plaintiff was non-committal as to what happened. That's false. A sworn affidavit declaration detailed counsel's testimony at the hearing, answered all questions asked by the court. There's no contradiction in my answers and how they comported with the declaration. And lastly, the erroneous fact that the plaintiff's counsel told the court that he did not know why he drafted a new motion for substitution. That's false. I was never asked. And the reason I drafted a new one is because I had planned to wait until after I was precluded by the statute, or Rule 25, I should say. I was precluded from filing it and was waiting to first obtain leave of the court to enlarge time before I filed it. And some days before the hearing, I decided to go ahead and file it to be heard. And as the pleading said, to be heard with the motion.
You can wrap up your point now. Your time has expired.
Thank you. To be heard with the defendant's pending motion, or to continue it to the next available date. So I don't think that should be used as a proof that I was deliberately ignoring rules of civil procedure. We therefore ask the court to find that the logic and reasoning was against the record and was an abuse of discretion that resulted in.
Thank you very much. I want to thank both of the attorneys for your presentation. Your case now has been submitted to the court. You will receive our ruling during the due course of time. Thank you very much. Madam Clerk, will you adjourn court until the next setting, please, or recess court until the next setting?